Thank you very much, Honorable Speaker. Honorable Speaker, I also want to join my colleagues, the minority leader and the majority leader. Number one, in commending and appreciating the judgment made by the highest bench, the Supreme Court, as far as public participation is concerned, Honorable Speaker. Honorable Speaker, there was, like the minority leader has said, this can only be related to a study in jurisprudence, Honorable Speaker, that you and I know on a particular case. We call it the Spelunchian Explorers case, Honorable Speaker. And you and I know that very well, where because of lack of written law and quality jurisprudence that would have either convicted or acquitted the explorers, the Spelunchian explorers, Honorable Speaker, there arose confusion in the bench where we found the Chief Justice hardly making decisions in that case. We found a positivist in the bench, I think Justice Keane. We also found a clear naturalist and one who even never wanted to touch. This question of public participation, Honorable Speaker, has brought a lot of confusion within our high courts and within our courts, Honorable Speaker, where one judge's view in the high court in Kajiado, another judge's view in Kisii, another judge's view in Kerugoya, another one in Mombasa, and another one in South Mogrango. Very soon we'll get a high court in South Mogrango. We are lucky to have a magistrate court so far. Honorable Speaker, when you read such laws, you will then be left wondering, and this House will be left wondering, which particular judgment would you, want to refer to when creating your own jurisprudence in terms of making the public participation worthwhile, Honorable Speaker. And that is why it is very important for this Supreme Court to have come with a clear distinction on what this House on what this House ought to do in terms of public participation. Because, Honorable Speaker, I was mesmerized by definitions of what a quality. I read one judgment that said what was a quality public participation. The parameters one created. What we are suffering from, Honorable Speaker, is actually what I will call judicial activism, where some people, and I say this with tremendous respect to members of the judiciary, where some members of the judiciary, Honorable Speaker, decided to be activists and populists, start making populist decisions. In fact, you'll be forgiven if you actually predict the outcome and then it comes exactly as it is, because you would see conversations on social media on how a judge would interpret this public participation direction, and the following day when you read that judgment, it is as exactly as it was written by some people on social media. This is mere judicial activism, Honorable Speaker. And the direction the Supreme Court has actually given us as far as public participation is concerned, it is a right jurisprudence. But again, I challenge this House to expedite the process of creating this law on public participation and create parameters. In as much as now we are using the jurisprudence that has been created, Honorable Speaker, it is important for this House to expedite such laws, and I think the chairman is here and is well noting, and then we expedite such process so that we do not have such similar confusions in future, Honorable Speaker, where the same procedure used on a particular bill is rendered mute, while a similar procedure that has been used on a different bill has gone through a similar procedure, passed and enacted, and it's now law. That kind of confusion, Honorable Speaker, couldn't be explained. We had lost quality on making our jurisprudence in courts, and we really must commend the honorable judges for coming up with such very serious directions as far as this jurisprudence is concerned. Thank you very much, Honorable Speaker.
Justice and Legal Affairs Committee.
Thank you very much, Mr. Speaker.
I've not allowed you to speak. Yeah, it takes the speaker to recognize you. When the speaker doesn't and you insist, you become disorderly and it may cost your presence in this afternoon. Yes, so you are not yet recognized. Let Honorable Murugara proceed.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, the issue of public participation is a very important issue in this country. And we allowed the Supreme Court for the interpretation and the guidance it has given to the House and to Kenyans as regards what exactly is public participation and to what extent should this House consider views collected from the public during public participation. Indeed, it is true, many people think that when we go for public participation, we should be collecting views and votes from the public, so that if the public votes against whatever it is we are proposing, then it fails. Nothing is far from the truth than that, because the fact remains public participation is purely to ensure that our public is well informed as regards the legislative proposals we have here or whatever action Parliament is taking, so that the public does not plead ignorance at any time. Two very important things to say. JLAC has two drafts of Public Participation Acts, which we are looking at. In fact, we had scheduled December to be our deadline, so that we are able to produce something for the House to look at. But we are happy to hear the Leader of Majority saying they are also working on an Act of Parliament, which will be coming to us in due course and which we will be debating when the right time comes. Because part of public participation is the question which recently, on Monday, the newly appointed Deputy President of the Republic of Kenya, Professor Kithure Kindiki, posed to the Judiciary. What is the difference between the public interest and the national interest? And which of the two is higher than the other? Because as far as public interest is concerned, and that goes with the public participation, there may be an element of mobilization towards rejecting a popular idea of the government. Is that what you should be calling public participation and the public interest? Or we should be looking at the bigger good of the country, what is beneficial to the country, and we should be carrying that as actually what entails public interest. All this is going to come before the House. We have to prepare